Today's topic is the fundamentals of construction contracts. So we're going right back to basics, possibly going back to your college days. So hopefully it's not giving you exam nightmares as we go through this, but just looking at some of the fundamentals, partly as a reminder, but partly because lots of issues that we, are very specific to construction contracts, have that fundamental base in construction law. So I think it's quite often good just to look back and have a reminder. So these are the topics that we're going to cover off. So you'll see they are very, very much construction based. So hopefully this is going to be, relevant and of practical use to you. We're not going to be, going on to some, very technical analysis of contract law. So that's just some information about Bevan, Brittan and me. So first of all, just looking at definition of a contract. Now, there are lots of different types of law, but of course in construction, pretty much everything that we do is based on a contract. But of course, the second bullet point is, the reminder that, a contract doesn't have to be in writing and isn't always in writing. So, sometimes someone will ring me and say, we're doing work or we're having work done. There's no contract. Well, generally speaking, actually, there will be a contract. It might just not, be something that's in writing. Sometimes it's sort of a mix. So, it might be some email correspondence, possibly some notes, but not actually something that's actually been signed between the parties. So what is a contract? Well, it's a bargain or an agreement between the parties, giving them rights and duties at law. Now, I'm sure that whilst we're talking about having oral or verbal agreements, you will always make sure that actually you do have a contract in place. Probably the more common scenario for you, and we're going to look at these situations, is doing work under letters of intent. So we'll look at what they are and how they differ from a contract. And spoiler alert, typically they don't, but we're going to look at situations where they do and where they're not actually a contract. The other kind of typical situation that parties get into, rather than there being nothing in writing, is a situation where the work started, the contract's pretty much been agreed, in terms of, a document, but it possibly hasn't actually been signed by one or both of the parties. So in terms of a contract, well, the first thing we need is an agreement. So they're the first two bullet points. So we need an offer and an acceptance. So the offer, might be, well, I'll do the work, which is X work, for a certain price over a certain time scale. The acceptance to have an agreement in place is that it must be a, yes, that's great, I agree that. It can't be a, well, actually, I want you to do work X plus a little bit, or happy for you to do work X, that's great, but, I'm not happy with your price. I want, a slightly different price, probably a reduced price. That's effectively a counter offer, which is in itself open to acceptance. So bear in mind that that acceptance must be unconditional. Now, where this comes in practice is typically where you end up in a situation where work started and that contract hasn't been signed. Does a contract exist? Have the key terms been agreed? Very often that they have, even though the contract hasn't been signed. So what the important thing is about offer and acceptance is to keep it documented. I appreciate the last bits of the contract that are getting agreed might be discussed over the phone. There might be a list of 3, 4, 5 items that are not agreed. There's a discussion over the phone, and right, we'll agree that 3 of the points, for example, are going to stay as they are, 2 are going to be amended. Very often in that situation, that call means that there's an unconditional acceptance. The parties are agreed, even though it hasn't been reflected in the written agreement. But from then on, there is an agreement in place. So there you've got a mixture of the contract terms with a few extra bits and pieces being kind of agreed before there is that unconditional acceptance. Other criteria, other points we need, so consideration. So one party, it's basically what is each part gaining from the agreement, and what are they going to be doing in return. So from the contractor subcontractor perspective, you'll be doing the work. The consideration is the payment you're receiving. From the paying party's perspective, they're making payment. To a great extent, their job is easy. Their key role is to make payment. And in return, they're getting something built. There must be an intention to create legal relations. Now, you might just think, well, let's ignore that. It becomes very relevant with things like letters of intent, and we'll see that later on. And also, typically, you're all working for organisations, construction companies, typically. So, if you've had an offer and acceptance and there's consideration, it will generally be deemed by the courts, by an adjudicator, that there is an intention to create legal relations, because the alternative is that work's being done on a voluntary basis, which, definitely isn't the norm. But, we'll see when we come to letters of intent how that might work against parties. So a lot of terms in contracts can be implied into the contract. Some of these, well, these are the key terms, which themselves can be implied. But, I think in terms of, getting on site and starting, these are the absolute fundamentals in terms of what needs to be expressly agreed. Otherwise, both parties could come unstuck. So price, performance. So what we mean there is the scope of work. Performance, so the scope and the price go absolutely hand in hand. The parties have got to agree, both of those. The period, so the time scales, again, really, really important. And also the parties, particularly from contracting, subcontracting perspective, that you are contracting with the party who you intend to contract with. Now, that isn't usually an issue. Where it kind of typically becomes a problem is where the paying party has a number of corporate entities, so a number of companies. You just need to make sure that you're contracting with the one which has the assets, so that you can ensure that you'll be paid. So offer and acceptance, just quickly deal with this, because again, it shouldn't be too problematic in the context of construction contracts. So offer, anyone with legal capacity can make an offer. So a valid company or an adult, point about the adult doesn't really apply to us. The valid person on behalf of the company will apply. And then, as we've already seen, it can be made in writing, or in a conversation. What I would say in terms of protecting yourself, if you've made an offer or you've received an offer, and it's not in writing, confirm it in writing. All it needs to be is a quick email, you know, a text, even something in writing. Email's probably better, just to say, you know, just to confirm, you know, you've, you know, invited me to do this work, etc., etc., and the terms discussed and what has been agreed. Acceptance is the second part of making an agreement. And as we've already seen, it's got to be unconditional. It can't be, you know, there's no acceptance if it's, well, you know, I'll accept, you know, the scope you're going to carry out, but, you know, I'd like a different price. What that is a counter offer. Consideration, we've already done that. An intention to create legal relations. So, you know, as I've already said, generally there is that intention when you're operating in the context of a business. So, you know, that's the context we're talking about now. Just be careful of subject to contract provisos. So we typically see that in a letter of intent, or in negotiations where, you know, you might have the contract, you're discussing it, you're debating, negotiating it. If all the emails passing to and fro are stated as being subject to contract, then that basically means you cannot end up in the scenario that I talked about earlier, where perhaps you've pretty much agreed all the clauses, you've got a few that are outstanding, and you have a telephone conversation and agree the last few clauses. Generally, at that point, you have an agreement, because there's effectively a meeting of the minds. You've had an offer and it's been accepted unconditionally. But if that conversation is specifically stated as being subject to contract, then what it means is, doesn't matter what we discuss in this call, the contract only applies. There's only a contract between the parties once what we agree in the call is reflected in the paperwork and both parties have signed it. So, particularly if, you know, you're a contractor and you're negotiating kind of down the chain and up the chain, you know, it's really important that your negotiations with your subcontractors are stated to be subject to contract, so you don't inadvertently end up agreeing a contract with them before you've actually signed up to the contract up the chain. So you sign up to your contract up the chain, and then you can end the subject to contract negotiations with your subcontractor, assuming you've got an agreement, send them the agreed contract and get them signed up to it. This penultimate bullet point, be careful of doing work for friends. So this case, bit of an unfortunate case, where someone did some kind of landscaping advice, gave some landscaping advice to a friend. They weren't actually engaged to do the work, and the court said that nevertheless the advisor owed a duty of care to the friends, so, you know, they were responsible for anything that went wrong. So, you know, just be careful there. You know, when you've had a few drinks possibly, and you're explaining to your friends, you know, how to extend their house or whatever. So moving on to letters of intent. So first of all, you know, why are they needed? So a letter of intent is typically used before, you know, the contract has been signed. So quite often it's pressure to actually start on site. Quite often it's for work such as ground site investigation, or some site clearance work, so kind of those early stages. And as it says there, it's whilst other technical and practical aspects are being dealt with. Quite often the contract negotiations haven't been concluded, So also actually, yeah, it's as it says there, it could be used to procure materials, particularly, you know, in this day and age where, you know, we've got problems with inflation, etc. For a contractor, hopefully it provides comfort that it'll get paid for this early work. For an employer, it means that work can start even though and therefore obviously hopefully the project can get finished earlier than would be normal, even though the contract itself hasn't been signed up to between the parties. So, you know, they're the circumstances in which typically a letter of intent will be used. What I want to look at is is it effective? So does it bind the parties, and how does it bind them? This last point, the quote, this was the judge's comment about a letter of intent and being careful of the perils of beginning work without agreeing the precise basis upon the work upon which the work is to be done. And the judge went on to say the moral of the story is to agree first and start work later. So that's, you know, the judge saying to all of us, do not go there, do not enter into a letter of intent. Which, you know, you may be kind of thinking, well, you know, that's all right for a judge to say, you know, in real life, it's a little bit different. So, you know, bear that warning in mind, though, and particularly in the context of what we're going to be looking at, and particularly the fact that letters of intent, we basically have two types: a binding letter of intent. So effectively, a binding letter of intent is effectively a binding contract, and a non-binding letter of intent, which is basically something that isn't binding on the parties, so it's not a contract. And it's not binding essentially because there's no intention to create legal relations between the parties and therefore no contract. Now, it's actually quite easy to tell the difference between the two. Let me just jump forward. Oh, sorry, I thought I'd right, I hadn't put it in. So the what you will the non-binding letter of intent, where have we got up to? Yeah, is quite easy to spot. So just kind of pause a minute. Usually because it's a pretty short document. You know, it's basically, you know, can you start on site, please? The key points are that it's clear that it's not binding on the parties, or that it's subject to contract. Now that makes sense, because if you think about it, what we know about subject to contract is that it means that, you know, there must be a contract that is signed between the parties. So if a letter of intent is marked as subject to contract, then it is saying this isn't binding until we have an agreement that is signed between us. So it's almost a circular thing. So your letter of intent mustn't say that it's subject to contract. Alternatively, if on the face of it, it says that it's not binding, so particularly if it says something like, we're in the process of negotiating a contract, you know, until, you know, that's been negotiated and agreed, there's nothing that's binding between us, but, you know, what we'd like you to do in the meantime is, you know, a little bit of site investigation, a little bit of clearing site, and if you could start that work tomorrow. So it's, you know, very, very short, but it's making it clear that it's all either subject to contract or it's not on a binding basis. Then typically this will be a non-binding letter of intent. So it's not forming any form of a contract. So you're not going to get paid for the work pursuant to a contract, because how can you? because there is no contract in existence. So the binding letter of intent, typically, bit of a spoiler alert, it will be quite a long document. So you're looking kind of 2 to 4 pages, possibly more. And the reason for that is it's setting out lots of sort of terms and conditions which are binding on the parties as far as that letter of intent is concerned. So usually, so the slide deals with the kind of issues that you would expect to be covered in a letter of intent. So those 4 Ps. So the parties, clearly, you know, as the party doing the work, you will want to know, you know, who the paying party is. Is it the party, you know, who has some money? What the price is? Now, that probably won't be the end contract price or the price that's been, you know, tendered. You know, it will typically be for maybe 100,000, few 100,000, just to cover the work that's the subject of the letter of intent. So, you know, the ground investigation, clearing the site, something like that, possibly, you know, some design work, possibly ordering materials. It'll cover a period of time. Again, typically this will be different to what you're expecting and what you've tendered for, because it might cover a period of 4 weeks, 8 weeks to do that discrete bit of work that is the subject of the letter of intent. And then also it should cover the performance, so the scope, what work's being done. Is it ordering specific materials and stroke or site investigation and stroke or some design? What is being authorised under what is effectively a sort of mini contract? Contractors and subcontractors, you know, you need to think about your key issues, so they're the same as the key issues in, you know, a normal contract. So limiting your liability. What's your standard of care if you're designing? It shouldn't be fitness for purpose. It should just be reasonable skill and care. What are the payment provisions? What constitutes a variation? You know, extensions of time, etc. So all those key clauses. What are going to be the employers, so the paying parties, key issues? They're going to be things like defects, you know, what's a defect, what isn't, delay damages in the event of a delay, what they're going to retain, so the retention from payment, whether any warranties, bonds, third-party guarantees are required. Clauses that are relevant to both parties, insurance, for obvious reasons, and termination. As we've seen already, the 4 Ps can be implied into a contract. The difficulty there is that as soon as you're asking a court to imply terms, you're sort of one step back. Typically, you would already have them in the contract or the letter of intent. So if you're asking a court to imply them, you've got that extra time and that extra cost of getting a court or an adjudicator to decide what terms are implied, and only then can you pursue the key dispute, which typically for contractors and subcontractors is going to be, you know, what you're entitled to be paid and when. Also be careful with letters of intent. You know, don't start work without any written agreement. You'll see from, you know, this slide that there's lots of information that needs to go into a letter of intent. So, you know, very often, you know, it I would say always needs to be in writing, of one form or another. Yeah, so just be careful of, you know, what work does it cover? Also be careful of the letter of intent expiring. So these are sort of specific issues that are included in letters of intent that are probably quite unique to letters of intent. So this point, first bullet point, it's not going to be the full scope of works that you've tendered. As we've seen, it might be just doing site prep, it might be just doing design. You need to be careful that that is the only work you do. Don't get sucked into doing more work without getting specific written authority to do so. So in other words, an extension to your letter of intent. The next bullet point relates to the letter of intent expiring. So quite often they're time limited. So you can do the site preparation for the next 8 weeks. So not only have you got to keep an eye on just doing site preparation, that's the only work that's authorised, but you can only do it during the next 8 weeks. If it goes beyond that, you're doing work outside of the letter of intent. So you're doing work that isn't within that little mini contract. Also beware of the financial authority being exceeded. So you might do the site preparation work, you might stick to the 8-week time limit, but if the letter of intent says you can incur a maximum of 50k, and within that 4-week period, within that 8-week period, you do some site prep that takes you up to 150k, again, you've gone outside of your authority, and that's not contractual work, that excess that you've done. So just to conclude on your letters of intent, you need to make sure the letter itself is a binding agreement between the parties. And as I say, usually it's clear from the words used in these kind of 2 to 6 page letters that it is binding. There's provision for X work to be done for a certain price, but you also need to keep an eye on the limitations and all of the limitations. So timescales, the scope of work, the payment. As soon as you're coming up to one of any of those being exceeded, you need to get an extension to the letter of intent, which needs to be signed off in writing. You also need to make sure that your letter of intent contains any key clauses that you require. So we mentioned earlier, particularly any cap on liability, on any limitation of your liability. And I say that because quite often parties start work on a letter of intent, contractor doesn't include a cap or limitation of its liability, even though it might be been included in its tender. But that, in my experience, then tends to make the negotiation of the main contract, so the contract that is going to be signed once it's all been agreed, more difficult, because I think when starting the work under the letter of intent, expectations are set, and the paying party, the employer, the client, whoever's paying, then has an expectation that there are no exclusions of liability from the contractor's perspective, and ditto with subcontractors when negotiating contracts and letters of intent with contractors. So this is just a quick summary, just to look at, going back to kind of the main heading, fundamentals of construction contracts. So I've done this for the NEC form of contract, but the idea here is just to think about what are the contract documents and being clear about the contract documents. So these are all the parts of the NEC form of contract that are fundamental to it. With JCT, the equivalent for probably the first 3 bullet points is the JCT form of contract. So if you're using the design and build, it's that. The 4th bullet point, Z clauses for NEC, the equivalent under JCT are the schedule of amendments to it. And then the last 2 bullet points are really the contract particulars in JCT, the bits that you complete that are specific to the project. But why I wanted to talk about this in particular is the other contract documents, really, really important. So, you know, for NEC, we have the works information and site information. And for the JCT, we have employers' requirements, contractors' proposals, etc., under the design and build. So that's, and I mean, that's absolutely critical. And it's critical that it's, you know, clear which draft is appended to the contract, because that's the work that's going to be carried out. So as I've said already, it goes hand in hand with the price. This is the work that's going to be carried out for the price that's being given. Also, other documents are typically collateral warranties. There might be a performance bond, parent company guarantee, all these sort of ancillary, what I would call legal documents, making sure that they're appended to the contract. And then the last two, activity schedule or bill of quantities. So, you know, the pricing for the contract, and then also the accepted programme. If the programme is going to be appended to the contract. So both of those items relevant to JCT contract. So that sort of covers the sort of form of construction contracts. I want to kind of look at some of the key clauses or types of clauses that we come across. And the first one is what we call a condition precedent. The first bullet point deals with the kind of basic position with regard to a breach of contract. So, you know, you probably did this at college. You know, you miss a time limit, or, you know, you break the contract, you don't comply with the contract in any way. So that includes not complying with timescales, not carrying out the work as you should, not carrying out the work to the standard that's set out in the scope, all these kinds of things. Anything that you do that isn't in line with what the contract says is a breach of contract. The fundamental rule is that if you are in breach of contract, then you must pay the other party to the contract damages. So typically it's a financial remedy, and it's the damages or the loss that flows from the breach. So, you know, if the work's defective, so it's not in line with what the scope says it should be, then the damages are typically the losses for making the work comply with the scope, and any other financial loss arising from it. If it's missing a time limit, then it's the losses resulting from that delay, so any losses that the paying party incurs. Now, a condition precedent is a different type of a clause, because what this does is, and it says in the third bullet point, if you miss, so typically the condition precedent has two key components. It has a time limit, and it requires, well, sorry, three components. Time limit, it requires a notice, and it specifically says that if that notice isn't given within the time limit, then the party notifying is not entitled to a remedy. So basically what it's saying is that if there's a breach of this clause, the implication of not complying, so not issuing the notice within the time limit, is set out in the contract. So the final bullet point, the features of condition precedent. First one, it specifies an action that needs to be taken. So typically, in this instance, it's talking about contractor, because typically they apply to contractor or subcontractors. Contractor is to notify its client, the paying party, of a compensation event. or a variation or an extension of time, the latter two under JCT. That's part one. Part two is the contracts provides a timescale for that notice to be given. So we know hopefully that notifying a CE under NEC, there's a timescale of 8 weeks. And the final critical component is that the contract specifies what happens if the notice isn't given or isn't given within that timescale. So we know with compensation events in NEC, it says that if the contractor doesn't give the notice within the timescales, so either if it fails to give a notice notifying a compensation event completely, or it gives the notice, you know, in 9 weeks when it should be 8, then the contract specifically says, this is the NEC, specifically says the contractor is not entitled to any payment or time in relation to that compensation event. So these are really onerous clauses, and that's a condition precedent. So it's kind of a procedural clause, but the implications of not complying with it are really, really onerous. They're not in any way procedural. So just be careful about that. Next one thing I want to look at is limitation periods, relevant in particularly for contractors and subcontractors, because typically this is about how long you are responsible for defects in the work that you've carried out. It also probably applies in terms of, you know, how long you have to claim, you know, your final account, albeit just be careful because under JCT and also now NEC4, both contracts have mechanisms to force a final account to become final and binding on the parties. And once that's happened, these limitation periods do not apply. So just bear that in mind. So the general rule is, so when I say general, it means subject to there being something specific to the alternative within the specific contract. The general rule is that limitation for a simple contract is 6 years. For a deed, it's 12 years. So that's a long time for being liable for defects. You can tell a deed because it states somewhere in the document that it's executed as a deed, or it's a deed somewhere it needs to say that it's a deed, whereas a simple contract will just say, you know, it will just say that it's signed. Obviously be careful because it's always subject to whatever is to the contrary. So if, for example, a simple contract says, you know, has a clause that says, you know, contractor, subcontractor, you know, is liable for defects for 12 years from the date of this contract, or 12 years from practical completion, then I'm afraid there's a 12-year liability. So, you know, you need to be thinking about both. What type of contract is it, and what does the contract say? And for example, you know, you might have a deed, so it might be executed as a deed, but there might be a clause that says, notwithstanding that this document's executed as a deed, contractor's liability, you know, for defects is, you know, 6 years, ends 6 years from the end of the defects period, something like that. So I think we've probably covered this, but I just wanted to kind of think about breach of contract in its widest context. So going back to what I said earlier, it's one, or I mean, it could be both parties, but one or other party not complying with its obligations under the contract. So hopefully, first of all, when we talked about, you know, the 4 Ps, those critical clauses, you know, and the possibility of implying them into a contract. And I said, well, you know, the difficulty there is, you know, that's all possible, but it means that in terms of pursuing a dispute, you're already one step behind, because your first step has to be go to court, go to adjudication to find out what terms are implied into the contract in terms of those 4 Ps, those critical clauses, or any other clause. So that's the first point. The other point is to bear in mind, you know, as contractors and subcontractors, you all have lots of obligations under your contracts. The reasons that construction contracts are so long, you know, and such lengthy documents is because, you know, predominantly they're all obligations that contractor or subcontractor under a subcontractor has to carry out. The paying party, the employer, actually has very few obligations typically. Their key obligation is the obligation to pay. But as we know, under the Housing Grants Act, their obligation, but they have an obligation to arrange for payments to be certified, and then for them to pay whatever has been certified, subject to any pay less notice that they submit. So that's their key obligation. They might have some others, so particularly in a NEC, the scope or the works information may, you know, require them to provide certain plants, certain materials, certain consents, you know, certain information, but it's typically not a lot. You know, the onus really is on the contractor or the subcontractor in a subcontract to, you know, to carry out all the work. So just bear that in mind. You know, at this point that the paying party, you know, really doesn't have that many obligations. You know, most of the obligations are on the contractor or subcontractor. So also want to look at excluding liability, because these are the clauses, the exclusions of liability or the caps on liability, excuse me, that typically will benefit the contractor or the subcontractor. So these are the types of clauses we've already, you know, seen need to be included in your letter of intent, need to be included in your tenders, and critically need to also find their way into the contract when you sign up to the contract. If, for example, you include some nice clauses to limit your liability in your tender, and then you sign up to a contract and those clauses haven't been included, then as a general rule, you will not have capped or excluded your liability at all. It will not matter that, you know, your tender was submitted on that basis. And that is because typically the tender isn't appended to the contract. Also, typically there'll be a clause in the contract that's signed that says this is the full contract between the parties. No other documents that have passed between the parties are relevant if they're not appended to this contract. And also, finally, even if the tender with those exclusion clauses is appended to the contract, there typically will be a clause which will say, you know, if there's an ambiguity in the contract, how that ambiguity is to be dealt with. Typically that will say the contractor deals with it at its cost. So that could very well mean that the exclusion of liability is deemed to be ambiguous with other clauses in the contract, so it doesn't apply because it's dealt with at the contractor's cost. Or there may be a clause in the contract that lists the hierarchy in the event of an ambiguity, and typically anything to do with contractor's tender, particularly anything submitted by the contractor, will be at the bottom of that hierarchy. So just be careful here. These clauses need to be carefully negotiated, carefully drafted, and carefully included in the contract before it's signed. particularly taking account of the third bullet point, because any limitation of liability clause, even if it is in that contract, it needs to be reasonable. So it needs to be drafted properly and really carefully. So if we start at the top, both parties, can try to limit their exposure to claims for damages. So, this is limitations can apply to both parties. You need to read your contracts carefully, because typically, if there is an exclusion of liability in those Z clauses or in schedule of amendments under JCT, it's quite probable that it will be the paying party, the employer, the client, limiting its liability rather than it limiting voluntarily the contractor's liability. So there are various ways, second bullet point, various ways to limit liability. We've already looked at, you can limit the time that a party is liable. So typically that will benefit the contractor or subcontractor. And we saw that in the context of 12-year liability for deeds, 6-year for a simple contract. There's nothing to stop you putting a clause in the contract to say, notwithstanding those provisions, a contractor's only liable for a year after the defects period or whatever. You can also limit your liability with a financial cap. So typically that might be the value of the contract. You can limit it by way of a net contribution clause, which is effectively saying, if there are two of us, two parties responsible for loss. So with a contractor, it might be the contractor and an architect. Then effectively, the losses paid by each and recovered by the party claiming is recovered based on the kind of culpability of either party, and that's to avoid from your perspective, the contractor having to pay up and then try to claim from the architect. Next bullet point, you might want to exclude specific types of loss. So for example, consequential loss, for various reasons, that's not a huge benefit, because it doesn't, for example, include loss of profit. Loss of profit isn't generally a consequential loss unless it's specifically stated as being a consequential loss. So, either party is going to be paying loss of profit typically. And also, a really nice one from your perspective, if you can get it agreed, is to limit liability to the cost of repair and replacement. It sort of depends on the work being carried out, and assumes that obviously some repair and replacement is going to be more expensive than others. For example, foundations, piling problems are always problematic, because quite often you can't repair them without taking the whole building down, for example. So, in terms of the final point, practical considerations to include, financial strengths of, all of the parties. Now, this would be at contract negotiation, and of course, particularly on, big projects, might take 18 months, 2.5 years, something like that. Financial positions can change. Think about the nature of the project. For example, you might want to, limit your liability for, ground conditions, but also, think about also including, the ability to make a claim if the ground conditions, aren't what you anticipated. And also, think about the PI cover and whether that's going to be, claims made and paid under the PI policy are going to eat into any cap on liability. And obviously from contractor, subcontractor perspective, you would want them to eat into that cap. General damages, so we're looking specifically, so we've seen, you know, what general damages means generally in terms of a breach of contract. If one party breaches the contract, then it has to pay the other parties, I mean, reasonably foreseeable losses suffered in connection or caused by that breach. So that's basically general damages. Now, we always, or typically, have a cover off in construction contracts for a delay situation. And the reason for that is simply the fact that construction projects are expensive for both parties. So the paying party typically will have some funding. So if the project's delayed, it means that it's paying for its funding without getting the revenue that it had anticipated in connection with the project. So, you know, hotels being built, it should have been completed yesterday. It's not going to be completed for another 3 months. The paying parties, you know, drawn down on much of its funding. It's paying, you know, its interest and, you know, the payment of the bank loan. We know interest rates are going up, so it's even more relevant now. But at the same time, the client, the paying party, isn't receiving any revenue to actually pay for that funding. But equally, if a subcontractor's delayed, it's got people on site, which it probably wants to, you know, divert and had plans to divert them to a new project. Lots of plant and machinery on site, all costs money. So that's why delay is probably, you know, delay is important in every contract, but it's probably why it's more important for construction contracts. So typically we have provisions to determine who is responsible for various delays, because again, you know, we've got different types of delay. We've got delays that can be caused by the employer. If, for example, the employer is in breach of contract, it was required to provide a decision about something by X date. It failed to do so, and therefore contractor hasn't been able to proceed. More likely, there's a risk that the contractor might cause delay. It should have completed work, but for whatever reason, you know, it didn't organise its staff well enough. It didn't have its subcontractor ready in time, all those things. Then that's the contractor's breach for not providing, for not progressing. And then, of course, there's a sort of middle items where, you know, technically it's not necessarily anyone's fault. You know, ground conditions weren't as expected. You know, the weather was bad. Statutory authorities caused delay. So these are all sort of neutral events, and typically the contract will deal with those. If it doesn't, then the general rule will be that the contractor is responsible for those items. So moving on to liquidated damages. So again, this is in the delay context. So we've already seen that, you know, you can generally have, for a breach of contract, you get general damages. If the contractor is required to complete by a certain date and doesn't, then you know, the first point there is they're in breach of contract, assuming they're not entitled to an extension of time, and they're entitled to that they're required then to pay, sorry, the paying party, the employer, is entitled to general damages, i.e. its losses in connection with that delay. Liquidated damages is exactly the same principle, except instead of having those general damages where the employer, the paying party, has to prove the loss that it suffered, the liquidated damages are stated in the contract, so no proof is required. All the employer needs to show is that the contractor hasn't completed on time and comply with any procedural requirements. Sometimes, so for example, under JCT, employer stroke contract administrator has to give a notice of non-completion and notify that it's going to be deducting the liquidated damages. So don't kind of get muddled about this. All liquidated damages for delay is setting the damages that are being paid in the event that the contractor is responsible for delay. Nothing more than that. And the final slide, just wanted to talk about third-party rights and collateral warranties again, because collateral warranties are actually quite a simple concept, but parties get very muddled often about what it all means. So the fundamental point here goes back to the issue of privity of contract. So if two parties, client and contractor, enter into a contract, we have a concept called privity of contract, which means that the obligations that are owed to the parties that are set out in the contract are only owed to those respective parties. A third party cannot come in and start saying, you two have got a contract, I want to enforce it and make a claim under it. That's not allowed. But you know, as you'll appreciate, and as is covered in this second bullet point, various third parties, you know, often have huge, you know, and often financial interest in construction works. So, for example, future purchasers, funders of projects will have an interest in the, you know, in the works, and so they will want to have the opportunity to make claims in certain situations. So another kind of misconception about collateral warranties is that if the contractor gives collateral warranties to a funder, it's already got a contract with the employer. It might give a collateral warranty to a purchaser, to tenant. It might have to give them to future funders. So the misconception is that the contractor is going to have huge liabilities against all of these people. And that's not the case, because at the end of the day, only one party will be able to claim loss, because only one party will have suffered the loss. As far as a defect is concerned, the reason that, for example, a funder needs a collateral warranty is, for example, the original developer, who was the client, goes into liquidation. The funder is left sort of holding this building because it's funded it all and it'll have a security over it. If there are defects, then it will want to be able to proceed against the contractor to get those defects remedied. So it can only do that because the original employer is out of the picture and not able to pursue the matter because it has no loss, because the funder's taken over the project. Similarly, where you have tenants and purchasers, one, if there's a defect, one will be responsible for remedying that defect as between them, and that is the only one, because it's the only one who will genuinely have suffered a loss, who will be able to make a claim under the warranty. So key terms under the collateral warranty, so this is the second main bullet point. It talks about duties of care. So, you know, if it's design, it talks about reasonable skill and care. It also talks about what materials standards are required. Also, it talks about copyright, and that's in the context of, you know, the work, including design. It also covers off insurance, so that's particularly professional indemnity insurance in the context of design, and also assignment, so allowing one party, so it might be a tenant, to assign to another tenant. And again, that's not giving several people the benefit of the collateral warranty. It is transferring the rights under the collateral warranty to another party where they have rights. So the third party rights is just an alternative to collateral warranties. It's not used at all. Often you'll see in that final bullet point, it was introduced 1999. So you would think, what, 23 years later would be using it more, because basically all it requires is in the main contract for provisions to say, you know, it's intended between the parties that third parties, and to name the third parties, or the type of third parties, you know, do get the benefit of the rights and obligations under this contract. So a lot easier than all the collateral warranties that we have to deal with. But I think the funders in particular are reluctant to go down that route. So we still, even now, see collateral warranties, which are time consuming and quite administratively onerous. So that's everything for today. I hope that was useful in setting out those kind of fundamentals. I'm happy to look at any questions now if we have them. I think my contact details are on the slides. Yes, there they are. So if you have any email queries in the next few days, you know, do drop me an email if you haven't got time to deal with them now.
Yeah, well, there's no questions in the chat, Sarah. So I'm assuming that everything you said makes sense, but otherwise, like you say,
clear.
Yeah, absolutely. I've popped my email address in the chat as well, guys. So if anybody does require a certificate or a copy of the recording link, then you can email me directly. So we'll call it a day, but thank you very much, Sarah. Great seminar.
Thank you.
All right. Thanks. Bye.